So as Rebecca said, I'm Kristen Goodwin. I'm Microsoft's Assistant General Counsel for Cybersecurity. And what that means in plain English is that for the past 10, 12 years, I have been lead attorney for the Microsoft Security Response Center and the Microsoft Threat Intelligence Center back before it was founded and since it's come together. One of the things that I think is amazing about the security community and particularly threat intel is that we all choose to come into this space because of the community and the opportunity to help and protect people. We all have different reasons for that. And so one of the things I would encourage you to do while you're here is to ask your fellow conference attendees, what's your security origin story? What's driving you if you're new to the space, or what brought you here? And for me, mine is that when I was a baby lawyer many, many years ago, I was working in a law firm doing a securities law, stocks and stuff like that, and I hated it. And I knew I wanted to change. And so I was hired by a company called MCI UUNet to help build their security practice. And so I left my job on the 85th floor of Tower 1 of the World Trade Center in 2000 to go and help MCI UUNet build its security law. And so from that point on, I'm all in. You know, my career will be always in security, and I am so proud to contribute to it and to help all of us at Microsoft and in the industry get better and stronger. So I would encourage you to go and find out what are others' origin stories, because almost everybody has one, and it helps us make our community stronger. This talk does not constitute legal advice. If anybody in the audience works for Microsoft, come talk to me later. Then it's legal advice. So I wanted to talk about how we think about maturing the threat intelligence sector with intent. You know, when the sector really started to kick off about a decade ago, we drove our interactions largely based on who we knew. I worked with someone back in the day, we came up together, and so the exchange of acorns from secret squirrel to secret squirrel was largely relationship-based. And that still exists in parts of threat intel. But we've also had this challenge over the past decade. You know, and you can see it with the advent and growth of conferences and important discussions like this, is that effort, money, resources, and need have come into threat intelligence in an unprecedented way. And that's really important because the way we grow is putting pressure on our sector. And so we have to think about the way we mature with intent. Two quick examples of that. Microsoft, and I'm not a product person, so I won't talk about products too much, but I think it's pretty amazing that we have advanced threat protection products, you know, threat intelligence products that are alerting customers about nation-state attacks. You know, they're that prolific that these are things we sell now. Those were not issues we had to contemplate 10 and 15 years ago. And so the evolution of our sector and the needs of our customers are driving change in a very significant way. And so as we are migrating our sector and maturing our sector, it's important for us to think about doing so intentionally. Now, a lot of that comes with the pressure of law, that comes with the pressure of policy, it comes with the pressure of contract as we provide products and services to governments. And so much of what we'll talk about today will be examples of how I have been working with my clients and others in the sector to think about how we mature with intent because of our evolution of our space. It's really all about the information that your company has. And there's a bit of a tension there, right? Because when we're involved in threat intelligence conversations, it can often be analyst to analyst. And so what that means is that the information that's exchanged is being exchanged on a personal level. However, it's not our personal information to share or to change. And those information sources can come from a whole range of places, right? It can be company generated, it can be acquired, it can be information that has been shared informally under TLP, and we'll unpack that in a little bit. And so when you are thinking about how cybersecurity information moves from a threat intelligence perspective, the sources of that and the context of that become incredibly important. And so it's when you think about how you're exchanging information or engaging from a threat intel perspective, it's just important to remember it's all about the information. this is the outline of the legal risk that we'll be talking about. We'll unpack info sharing. We'll talk about sharing with government. We'll also talk about incident response. And then my favorite, successful disruptions of nation-state attacks. This is really one of the most important things and sort of the epicenter of how we think about threat intelligence. And what I would encourage you to do is that think about a principled approach to information sharing. As you break down the categories of information that you have from a threat intelligence perspective, they fit into buckets. Some of these things are indicators or IOCs that you have that are not confidential information or things that you found in open source. So those are things you should be comfortable sharing, and you wouldn't have any issue providing those to others in the industry. Then you move up the scale and other classes of information, maybe things derived from customers, maybe things that you've developed through your own threat intel processes or tooling. That becomes more confidential. And so, thank you. As you think about what is there and what you have, when you have a principled approach to sharing, then when the crisis comes, you don't have to panic. And really, as an attorney, that's what I'm looking to do, is I'm looking to minimize risks. And so if you can develop a written approach, how you think about sharing, what is high sensitivity, what is medium sensitivity, what is low sensitivity. In my view, you're giving freedom to the analysts because they've got rules of the road, and you've got a place to come and a partner to work with when you run into those questions. Now, one of the things that's really the lifeblood of sharing are the tools that we use. I've put Slack and Signal up here, a little hope for teams, and I'll explain why. So I actually am not your attorney, but I do not want a show of hands of the number of you who have set up Slack channels or Slack accounts with your personal credentials, because it's so common, right? Like, we set up Slack accounts with our personal credentials. Now imagine you're in a cyber incident and you need to pass some threat intel to somebody at another company. So you're going to take information, sensitive information about an incident in your company. You're going to take it from your corporate account into your personal account. You're going to then transmit that through a non-company channel to a third party. So what we call common in threat intel is what a litigation attorney calls a nightmare. And so have that conversation now, because as our sector is maturing, we need to mature with intent. There will be scenarios where a customer or something causes a lawsuit. And if you have planned in advance and your team knows that you will be using Slack or Signal, then you have a process and a means to be able to manage that. But for most companies, there probably is a policy that says you should not be using personal accounts for the transmission of corporate data. And so rather than putting yourself into the position of explaining after the fact, force your teams and your attorneys to do the homework in advance. Not going to say that's a lesson learned, but it's something that's important to think about. And push on your company and push on others in the industry to develop enterprise spaces so that this type of sharing can come, and you don't have to act like the individual or a rogue at that point. You are covered by the policies and the defenses and the liability management systems of your company. And you have a way to manage the value of that exchange, and you're not being put in the middle of it. So let's do a sidebar. You know, as an attorney, we like to go off and talk to the judge and have a conference. I wanted to have a discussion about the traffic light protocol. This is the lifeblood of the threat intel space, and it is a real challenge from an attorney's perspective. So TLP is a standard that was developed by FIRST. If you haven't visited Traffic Light Protocol, you can go to the Department of Homeland Security's US CERT website and visit it there, red, yellow, green. And what it is essentially an honor code. If I pass information to you and I tell you that it's TLP red, it is for your personal use and not for distribution. Or amber has a bit of a broader space. Green means you can share it widely. Now, the challenge is that if you're a government employee, you don't have the legal ability to keep something at TLP red. And so if you are in a conversation and you truly need something to rest with one person alone, that is a near impossibility from a government perspective. On the private sector side, we struggle with the concept of TLP as a legal community because something can't be partially confidential. It is either confidential information or it is not. And I've seen a number of attorneys try to bring TLP into a contract, and that concept has not succeeded. And so I think that as we are maturing as a sector, we're going to see more tension around this and the need to think about how we mature with intent the way that we share, because the personal system that is developed will continue to be stressed. And so I don't have a solution for it, but it is something as an industry we will have to go and solve over the next 5 to 10 years. I wanted to spend a little bit of time talking about working with the US government, because it is a growing and really important space. And there are things that are really important to think about that come up as we watch the threat intelligence space grow. We are going to see more and more requests for information coming from the government in this community in particular, because of the weight that is being placed on threats to the election, threats to critical infrastructure, threats to democratic processes and institutions generally. And so it's important for you to have a good partnership with your attorneys to understand the context of the questions that are coming into you. So it may sound basic, but all government employees have an obligation to make sure that they are not binding the government without permission, that they're not giving preferential treatment to one company over another, and that they're not violating law or ethics. I bring this up because if you are in a conversation with a government employee and you're trying to share information and they tell you it's TLP red, that may be a challenge, and that's something to go talk to an attorney about. You watch how the government is maturing its threat information processes. They did so in a great leap with the Cybersecurity Information Sharing Act a couple of years ago, or CISA. And they created a definition of cyber threat indicators. And they also created a scope for how the US government can use that information. And that's really important, because our industry in threat intel is predicated on relationships. Now, I know you, I know how you're going to share and use this, and I trust you. But with CISA, what that does is it tells us how the government is going to use our information. It can use our information for a cybersecurity purpose, or to get really boring statutory language, the purpose of identifying a cybersecurity threat, including the source of such a security threat or a security vulnerability. So basically, for anything, if there is a need to use this information or share it, disclose, retain, and use by any federal agency or department, that means it's going to be shared and used broadly. And that's just an important thing to keep in mind, because if we have the secret squirrel history that we're working to evolve away from to a more structured engagement, this tells us, this was a stake in the ground from the US government that said, this is how we're going to work with the private sector. This is how we're going to treat your information. And so that context matters a lot, because the focus of the US government right now is on identifying the next attack and helping to mitigate it. And now much of that comes with the private sector and our responsibilities on the front lines of a lot of the attacks that come. But this is the stake in the ground from the US government that tells us how they are going to look for their authorities and their abilities to leverage and mitigate attacks. Understand the authorities of the agency. The NSA has foreign intelligence abilities, so they're looking outside the US. The Federal Bureau of Investigation has some domestic capabilities, some foreign. Department of Homeland Security does not have subpoena authority, but they're looking for that. So there's a lot of different things to keep in mind. And having a partnership with your attorneys helps you understand, when you're talking to these different agencies, what can that agency do with your information, or why are they asking the question? The law will always prevail over the policy, and so understanding both of those helps give you context. I wanted to recognize from a cybersecurity perspective that the US government has made some really amazing investments in the Department of Homeland Security and in the NSA. It is not a surprise that you have leaders like Chris Krebs at CISA or Ann Neuberger at the NSA doing cybersecurity community outreach. Both of these folks are very interested in engaging with the private sector and wanting to partner in new ways. And that's exciting for us because what that means is that threat intelligence has matured to the point that this is the first question. What are you seeing? What do you know? What can you share? And so that's an important evolution for us, but it's also additional pressure on the analysts to understand how that information is going to be used. Same thing with regulatory agencies. You're seeing an increase in interest from the Treasury side and from the Department of Energy because they have oversight in broader communities, so they ask a lot of questions. And of course, you can't forget Congress. Congress is a victim as much as it is a participant. So if you see cyber indicators that show issues that are impacting the House or the Senate, Senate Sergeant at Arms for the Senate side, House Technology Office for the House. So that's them as customer or victim in an attack. But we also have oversight committees and we have congressional committees that have an interest in security. And we have an interest in helping them understand the context around these issues. And so it's something to keep in mind when you're engaging. It's not just the technical conversation you are having with your fellow analysts in the government agencies themselves. It's also explaining to Congress why something is important or why actually that's not such a big deal and you shouldn't be so worried about that. Engaging with law enforcement. You know, what I hear over and over again from those in the threat intel community is, I have a contact at that field office, you know, we've known each other for years, we worked together way back when, and you know, he called me the other day, we were sharing some information, he gave me some indicators, it was really great, I gave him some stuff back. So, allow me to tell you a story. So about a week and a half ago, I was at the Department of Justice catching up with a colleague in this space there, who made the comment that usually within an hour of a conversation with a law enforcement officer, we know if there's any interesting information there. And there's a reason for that. So the FBI's policies around how a law enforcement officer can behave requires the sharing of that information with the lead attorneys on the case. And it usually happens very, very quickly. And so the concept of, you know, well, I've got this buddy, he's been at this field office forever, we've worked a bunch of cases together, that means that he's not only a friend, it means you're a confidential informant. And you're probably a confidential informant who has not been consulting with your own counsel about that fact. If you've been having conversations with somebody and you haven't brought your attorney in. Now, I am not saying by any stretch that you should not share information with law enforcement. It is extremely important that you do. I think that the work that's going on right now with the FBI and DOJ on some of these large nation-state cyber attack cases is incredibly important. And when you read the charging documents, they're like Grisham novels, 150, 175 pages of really thoughtful analysis of the attack. So they're doing great work, and that's really important. But the reason why I'm pushing on this point is because this interaction is very, very frequent. And as we get closer to the election or major events where our government officials are working so hard to protect the country, they will look for information to help them advance their cases and protect whatever the issue is that they're worried about. It's also important to keep in mind that if the US government is successful going after one of these persons, the defense has the right under the federal rules of criminal procedure and under Supreme Court case law to examine the evidence that was provided. That means that those IOCs or that account or that information that was provided to that field agent that then got into the case and now is being used to go and help convict that bad guy, that nation-state actor, that's going to get turned over to the defendant And you may have to go and actually appear before court to go and corroborate that evidence. And so I highly recommend, as you think about how you're engaging, call your lawyer, right? It's an easy thing to do, but it will protect you significantly as you go down the road. Another sidebar, let's talk a little bit about attorney-client privilege. Attorney-client privilege starts when you ask an attorney a question. It's a really easy thing to do when you send an email to an attorney in your team, and you just write attorney-client privilege on the top. If you're in a hurry, ACP even works. And you ask a question. You're asking for legal advice. Now, at that point, that communication becomes privileged because you are consulting with counsel. And what happens when a company can be compelled to disclose information? Well, it can happen if the information is being applied in an unrealistic way. So you can't just put attorney-client privilege and then have a long discussion about threat intel and then come back and ask a question. The judge will probably overrule the privilege and only cover that specific question. So you have to be careful and thoughtful about it, but it can protect your information from being disclosed. We learned a lot about the limits of attorney-client privilege over the summer when we saw Mr. Cohen's privileged information released in the criminal case against him in the Southern District of New York. So it's a great example of how criminal activity cannot be covered by privilege. But as we see our space mature, this is an area that will take on more importance. So it's something to make sure you understand when you're working inside your company. So incident response. This is when we are really talking about information sharing under stress, right? You've been retained by a company, so you may be going in to do a forensic investigation. You may be the victim, so you may be doing that investigation for yourself. You may be learning about an incident that's impacted a third party and looking for information within your own systems. So incident response can come from a number of different places. One of the interesting things that we're seeing is an increase in the retaining of services, forensic services, response services, to come and help companies that have been victimized, ransomware, or run-of-the-mill cyber attack. And the attorneys are retaining the threat intel teams or the response teams to come and do the cleanup, which means that all of your information is arguably covered by privilege. And so what you can bring out of that conversation, bring back to your company, bring back to other engagements, becomes a really tricky thing. And it's worth thinking about that in advance so you understand with your own attorneys what can you use and what can't you use. That will happen more and more. The other thing that's really important in the incident response space is to stick to the facts. I have seen way too many emails over the course of my career that tell me in the beginning of an incident, like the internet is melting, and we're all gonna die. And so it's really important to make sure you don't overstate. The internet's not gonna melt. It might just thaw a little bit. And so as you are unpacking the incident, try to be as factual as possible. In almost every incident, there's a communication up to the executives. There's a communication to your comms team. You're all communicating like crazy back and forth, hopefully on company channels and not on Slack. All of those communications, the more factual they can be, the better. And when you are stressed about something and you really feel like you are in need of venting, pick up the phone. That's a canonical rule as an attorney is when in doubt, pick up the phone, have that conversation with somebody. And then it's a much harder thing to address in court than the physical written record of. So at this time, Ms. Goodwin, you wrote that the entire North American internet was going down forever. Is that correct? Yes, I wrote that. It's not a good conversation to have in court. So those are some of the things that we think about when we're dealing with incidents. So let's talk a little bit about attribution. Let's have another sidebar here, because this is an area that's really growing, and as the threat intel community matures, we have a lot of work to do here. The law is really struggling with this concept of attribution, and we're struggling with it at the international level, and we're struggling with it at the national level. So in the US courts right now, there's a case between Mondelez Corporation and Zurich Insurance. Mondelez was hit pretty hard by NotPetya, and so they sought a claim for millions of dollars under their insurance policy from Zurich. Zurich denied. They claim that the NotPetya attack was an act of cyber war. It's a pretty fascinating thing. Now, we had 7 statements of attribution from governments attributing that attack back to either the Russian government or various actors inside the Russian government. And so there is an attribution that is there. And obviously, law enforcement is very involved in getting down to the individuals behind that attack, but we haven't seen those indictments yet. And so the court in the Mondelez case is wrestling with the concept of when is an attack an act of cyber war, and can you disclaim that from a policy perspective? And the ability to declare a war means you have to determine that there is a nation state involved. And so this area is going to continue to grow. We're going to watch this case very closely as it works its way through the courts and probably has an appeal or two. But it's going to continue to evolve how we're thinking about this. And the whole sector is watching it very, very closely. A question I get a lot from threat intel analysts is what happens if the attribution is wrong? Now, there's a possibility that it is. Anybody here who's on Twitter can see that there's a debate all the time about, is it this actor, is it that one? We have a slightly different take than others. Legally, that's less of an issue today. It's not like Strontium or APT28 is going to call Microsoft and say, we're going to sue you for defamation because it was actually APT29, Yttrium. Like, that's not going to happen. It would be so awesome if it did. But that's not going to happen. But what is going to happen over the next 5 or 10 years, as our sector is evolving, customers are going to rely on our guidance. If we tell a customer it was APT28, they will take steps that reflect how we have advised the world to go and mitigate APT28 threats. If it turns out we're wrong and it was somebody different, so they missed the IOCs or the TTPs that they should have been hunting for, there can be liability that's there. And so this concept of attribution is going to continue to evolve, and how we think about it is going to continue to evolve. And that's an important thing for all of us to keep in mind, is that this bar is sliding. And it's also really important because as we as a sector are going to have to mature this concept and start to think about things like standards and policies. And I remember years ago being told, that's impossible. This space is so complex. We could never get a standard or common approach. But now we have the MITRE attack principles, and we've got Katie and a lot of others to thank for that. And so it's shown us we can do that. We can have a standard in this space. And we will need to look for ways to develop a common parlance for customers who are going to need it and want to understand how things work more consistently, and for each other as we see more and more of these attacks and how we talk to each other. And so even potentially CVE numbers, ways that how do we separate out attacks from others and enumerate them. These are things we are going to have to think about as we mature. And ironically enough, it's liability that helps push us to go and think about things like this. Let's talk about nation states. This is where I spend the bulk of my time. We've really been evolving how Microsoft thinks about nation states. The conversation started with us looking at threat intelligence and trying to think about how threat intelligence tells a story. Now we're in the process of hiring threat context analysts. So I've got a Russian threat context analyst on board, and I'm hiring context analysts for Iran, China, and North Korea. And the reason that I'm doing this is because Microsoft looks at nation-state attacks as something that we need to help explain to the world, that when a nation-state launches a new cyber attack, we don't have rules of the road that govern that. And so we have called for the need for a digital Geneva Convention, and norms of government behavior and how they act in cyberspace. But it's really clear that when we see these nation-state attacks, we have a persistence problem, that anytime a new nation-state tactic is developed, it gets launched against its target in a narrow and defined way, and it is often quite successful. And then it is identified, often by somebody here in the room or somebody that you know. And then we'll have to develop a mitigation for that. And we'll push out a patch and we'll work on that. And what's amazing is that the persistence of that threat exists forever, or as long as the technology is in existence. And I'll use examples like Stuxnet. Still cleaning that off of machines. Conficker, a botnet that we helped take down, not a nation-state botnet, a cybercrime one, but the malicious software removal tool is still pulling that off of millions of machines a year. And so our view is that we need to do something. We are working very hard on the policy side to get governments to accept this concept of a digital Geneva Convention. And then I get to work with threat intel and the operations and technical side to think about how do we do nation-state disruptions. And that's the really fun stuff. But what we do is we have to have a legal framework for thinking about how we develop these types of interactions. They are very high risk. You have to be sure that you have a principled approach, because the penultimate question is, what if we're wrong? What if the infrastructure that we are looking at actually belongs to somebody else? What are the unintended consequences? Since my dad's here, I can tell a story. So one of the things that I was always told at the dinner table is that when you have a really tough question, always plan for the 5 or 10 things that you don't want to have to answer. Because if you can think about answers for those, then chances are you are doing a pretty good job of managing your risk. So go 5, 10, in your most significant cases, 15 layers down of what are the things that can get me here. And that will help you develop clear principles and a clear risk management approach, so that when it comes time to actually go boom, then you've got a clear understanding of what your risks are, and you're not surprised. Another really important area for nation-state disruptions is that they're very hard to go alone. And so if you're going to be working with partners, then you need a very clear legal agreement or legal understanding or MOU that details how you are going to interact with those partners. What TI are you going to exchange? What are you going to do? What are they going to do? Are you going to do communications about it? Are you going to notify a government partner? Are you going to have a media campaign around it? These are really important things to think about in advance, because once you go boom, you are guaranteed a call from a government and a subpoena. And so if you have planned for those, then they become things that are easy to respond to and a part of the normal routine of the disruption. And so at Microsoft, what we've done, we've looked at both legal and technical disruptions. And this has been an area that our digital crimes unit has helped pioneer this concept of legal disruptions. You know, the first one we brought was against Strontium, APT 28, where we've been seizing domains. We've been doing it for several years now. We have what's called a special master. So judges can be really hard to get on their calendar. When you meet with them, you know, it's really hard to explain what a domain is, let alone how a domain is owned by a nation-state actor. And so in that case, we have what's called a special master, a judge that we can train, who understands the technology, who can respond quickly. And so in the 10 to 12 times over the past few years that we've seen Strontium setting up new infrastructure, we can go to court, we can get an order, we can get that seized, sinkholed, and then we can notify any victims that we see. And that theory is applied pretty much throughout all of the different cases that we have. We've also done technical disruptions, right? So in those instances, when we were looking at either accounts, malware, anything that we can identify in our domain or there's a violation of a terms of use, or there is a breach of a service agreement, then we have the right to shut those accounts down. And so as we think about that, that's a really powerful tool to have. And so we have to be incredibly coordinated on it. And of course, when you're dealing with a nation state on the other side of the table, removing accounts or attack infrastructure is a disruptive effect. It is not going to be the end-all be-all, right? These are well-funded, they're called advanced persistent threats for a reason. But the view is that if we are persistent enough, if we continue to shine a light on this, then we are highlighting for nation states what is acceptable behavior in cyberspace and what isn't. And the more we can talk about this, and the more we can highlight that there is unacceptable behavior that goes on in nation states and in cyberspace, and we can and have to do more, eventually it hits the public conscience. We would love to have others join us in thinking about ways to disrupt this type of behavior, because what it does is it sends the message of, for those of us who operate the infrastructure of much of the internet, that there are rules of the road and there are consequences. The fact that we all have to update our computers when a new piece of malware gets launched, that has a cost. And when that cyber attack persists, or the malicious software removal tool is pulling the same malware off of a consumer's machine month after month after month, that has a societal cost. You know, the cost of the initial cyber attack may be small in terms of how much did it cost to acquire the vulnerability, or how much did it cost to build the malware or the payload. But when that payload is then out in the open internet and it is being used again and again and again, and we are all helping our parents remove it from their computers, not Dad, he's really good at that, but it's an important thing to think about. It's a societal cost. And so we are very focused on how do we change the dialogue there. If I can leave you with a thought today, it's that you are all the guardians of the galaxy. You are the ones who are going to spot the attacks before they happen. You are the ones who have the hunch. You are the ones that stay up incredibly late, giving up your personal time, missing family events because you're hunting. And you are the ones who will be the watchers. And that is so important. You know, my job, if I do it well, is to remove obstacles and impediments from our hunters so that they can continue to do what they do. But I can't help issue spot for them if I don't understand what they're doing. And so if you've got a lawyer in your orbit, find them, bring them under your wing. I was incredibly lucky to have amazing engineers at UNet and at Microsoft along the course of my career that helped me understand the technology, so that way, when the time came, I could ask better questions. And you're all in the position to do that because you understand the technology, you understand what you're hunting, you understand the forensics. And so bring them into your orbit, bring them into your community, make them a part of your team. And that way, when you're under pressure and it matters, you have somebody that knows how to respond and respond well. So with that, thank you very much. I really appreciate, whoopsies, going the wrong way. I really appreciate, I can't drive. I'm a terrible driver. I really appreciate all of you. Thank you for having me here. And I don't know if we want to do a couple of questions. I'm happy to do that. And enjoy the rest of your time. Thank you.